Right. So sorry about that. I just started the recording. Again, we're going to hand it over to Greg Tinch, who's going to go into IP law and all the stuff around that. Greg, why don't you take it over?
All right. Thanks, David. Welcome, everyone. Thanks for joining. My name is Ken. Oh, wait a minute. Let me share my screen. All right. I think, are we good? Can you see my slides?
We do not see them yet.
All right. Somebody cue the hold music. 1, 2.
Do you see the share screen button at the bottom of the Zoom ribbon?
Yeah. Just oh, sorry, everyone. Can you still not see it?
Not yet.
Okay, I'm like, sorry, everyone. Technical problems. I might get kicked off, but I'll be right back.
Okay. Well, so that everyone's not looking at dead space, I'll be here. I handle the I-Core program, which often people come to us asking about IP. And so if you are thinking of questions for Greg when he comes back, please feel free to get them ready. Just anything around copyrights, patents, how startups should handle that as a business resource. So just start thinking of your questions. Sorry for the delay.
Okay. Oh. I'm still having problems sharing, David.
If you email me the slides, I should be able to share them for you, actually.
Okay, sure.
I was feeling some dead space, Greg, so I mentioned the program that I help run, I-Core, so I'll quickly give a quick plug. I-Core helps faculty and startup researchers looking to commercialize their research. So often they do have intellectual property that they're trying to turn into a startup. And we help them with customer discovery and then kind of the next steps of, okay, validate your business model and now go look for additional funding after our program. We do also work with Maryland entrepreneurs beyond the core research faculty, but we can talk about that another time. I definitely want to give Greg the space here. Or you can also reach out to me. I'll leave my email in the chat. Greg, did you send over the slides already?
One moment, I'll send them.
And someone already thanked you for hosting this webinar. So thank you for that. Technical difficulties, everybody.
Yeah, not off to a great start. I'll stay longer if everyone has the bandwidth.
So Greg, you can either share me the link since you're using Google Slides, or you can do the download as PowerPoint.
Okay.
Another option.
I'm sending the link now. That's PowerPoint. And I'm also going to share. All right, I shared everything.
Just wait for the email to come through here. Thank you all for bearing with us. We really appreciate it. We would definitely, I'm just waiting for the email to come through, and I will get these slides going.
I mean, if it's okay, I'll just jump in because we're like 10, we're 10 minutes in, so I'll just jump in. So first, I will reintroduce myself. David gave me a nice introduction there, but I am Greg Tinch. I am principal of Tinch Law Firm PC. It's a business law IP practice based in the UMD Discovery District. I handle aspects of business law, including like intellectual property, contracts, business formation. I also have a civil litigation docket that I handle, not huge, but it has come up. And my bar licenses are Maryland District of Columbia. I took an exam to practice before the Patent and Trademark Office, practice patent law before the Patent and Trademark Office. And I'm licensed to practice before the Supreme Court as well, even though that hasn't come up, I think, thankfully. That's me. So quick overview of what I want to discuss today. I want to do a quick overview of the aspects of business law that fall under that big heading. Then I want to zero in on a couple subtopics there. So business structure and organization is, the title was around patent law, but the more I thought about it, I thought that the fundamentals needed a broader view of business law. So business structure, then I'll talk about intellectual property considerations, mostly around patent, trademarks, copyrights, and I'll also talk about contracts towards the end. So business law overview. Sorry, David, I'm trying to track you on my side with my own slides. So here's the aspects of, so business law is an umbrella term, and it has these like sub-specializations within it. The sub-specializations, you can see them here. I won't read them all out, but in my view, commercial transactions will matter. Business structure will definitely matter. IP will matter. Contracts will matter. Employment law will matter. Governance will matter, but privacy, securities, antitrust, bankruptcy, and consumer protection probably won't come up for you at this juncture. Definitely hope not bankruptcy or antitrust. I can give you a bigger, sorry, let me mute the sounds on my computer. I can do a deeper dive on those for, if anyone in attendance wants to know, but just for the sake of time, we'll just put those to the side and for me, it's enough that you know they're under that umbrella if you ever have an issue come up. And just, just quickly, I think my macro goals here are to give you an analytical framework so that when business law issues come up in whatever form, and they will, I want you to be able to recognize them and either come up with a high-level plan yourself or have the recognition that you need to like bring in a specialist or get help, have a consult with the competent attorney in that practice. A moment here. So yeah, all right, David, I'm ready to go to the next slide. I wanted to give a quick anecdote about like when I was studying my ME undergrad classes, I took the engineering physics class, and I remember underperforming on a midterm, and I felt like I devoted the time I needed to the homework, but I just kind of wasn't getting it. And there were a whole bunch of formulas. And I remember trying to remember all the formulas. And then eventually it dawned on me that there were maybe like 3 or 4 key formulas, and you could figure out the formulas down the stream from these main ones. So, I think that's my high level view and goal for this presentation. Effectively, I hope that you understand kind of the primary colors, if you will, and then you can make the secondary colors after that if you need to. But if you understand some of the big ideas, then it will help you think through and do some analysis for issues that'll arise in your business. All right, David. So let's say you just start business and you don't file anything. You can do that, it's legal. This will make you a sole proprietor. That's a de facto business form in Maryland. So, the pros of a sole proprietorship is there's no formalities. You could just get going like right off the bat and start selling your goods and services. Now, let's say Zealous Greg wants to just go out and take clients and take cases. So I file a trademark application for someone. I get an office action. 3 months go by and I just didn't docket it. I missed the deadline. I lose a suit to the client. They sue me for $50,000. My business has $30,000. So they take that. But then they could attach like my car, my house, any of my personal assets to get the other 20,000. That is the downside of the sole proprietorship. You're personally liable for the debts and obligation of the business. So that fact makes the sole proprietorship kind of radioactive to investors, because even if they believe in what you're doing, they don't want to be on the hook if something goes wrong for all their personal assets. The owners are personally liable. So, word of caution. If you're doing business, but you don't have a structure, this is your situation, probably. But we will talk on the next slide about how to deal with this. So an entity called a corporation evolved. There were these problems, like if you had a capital intensive venture, you couldn't really get investors because of the liability. And then also, before the corporation existed, investors could exit the venture at any time. So that caused uncertainty. And also limited the, the projects that the venture could take on. Sorry, my slides are behind now. So my research found that the first organization was the Dutch East India Company, and the charter solved these problems by first, the charter made the corporation's existence perpetual. So if you were an investor and you got in, you couldn't just get out at a whim. And then also it limited the liability of the investors and the owners to the assets of the corporation. So in my example, if the client sued me for 50 and the entity had 30, they would take the 30 and that's it. The corporation under Maryland law has these other powers as well. Perpetual existence, they can sue and be sued and make complaints in court. They can own property, they can be a party to contracts, and they can convey interest in their assets as well. So there's more powers under the Maryland statutes, but these are the ones that are going to come up again. They will be common threads throughout this presentation. Next slide. I want to have a point of order here, business law point of order. So the corporation can sue, or the entity, not just corporations, can sue or be sued. And it is an entity separate and apart from you. It is not the owners or the founders or the employees. It's a separate thing. So that means if you own a patent and your business owns the patent, you find out that a competitor is infringing on your patent, your business can be the plaintiff and raise a patent infringement claim against the infringing party. This also means that if your business has employees and your employee is involved in a civil action, or maybe it's a business litigation, but this means that your business can be subpoenaed in other cases, and they could ask your business to turn over employee documents or documents that the secretary of the business has custody over. So yeah, I just want to flag that. So I think there can be a tendency sometimes. You have a early stage venture, you don't have a lot of capital, you don't want to hire an attorney, but you have to consider that maybe you have shareholders, maybe not, but the corporation is not you. What may be good for you is not necessarily good for the corporation. And you really have a fiduciary duty to protect the business. Sometimes that means hiring counsel to deal with third-party discovery issues and the like. Let's check on my notes here. Okay, next slide, David. Next slide for me. So these are the usual entity choices for like earlier stage companies. So you have corporations. Corporations issue shares. They give out equity by issuing shares. It is owned by the shareholders, and it's managed by the directors and officers. The corporate governance document of a corporation is the bylaws. It's not a statutory requirement to have bylaws, but I think it's a good idea, at least to think through them, to think about like the decision tree and how your corporation should be managed. limited liability companies are, limited liability companies and limited liability partnerships are further evolutions of the corporate form. So the real advantages of these forms is the limitation on liability and then also the tax treatment. So a subchapter S Corp, a LLC, a sole member LLC, and a limited liability partnership can all elect to be taxed at the individual level instead of the entity level. So a normal corporation, the corporation will pay tax and the shareholders will pay tax, but an S corporation, the profits of the corporation pass through to the owners and they're taxed on their personal tax only. You still have to file a tax return, but the income tax flows through to the owners. And one moment here, David, I'm looking at my notes. Unless anyone has a Q&A on this, I will move on. And yes, to answer some of these questions I see in the Q&A, yes, I can share the slides. Give me a day or so to take off my speaker notes, but I'm happy to share the slides. All right. So, this webinar is called Practical Considerations. So these are some practical considerations. The number one is that your entity is separate from you, the owner, or whoever the owners are, unless you're a sole proprietor. So that's important. And I think the governance documents like bylaws, a member agreement for a LLC, a partnership agreement for an LLP are key to helping you understand your decision tree and how you should make decisions for your entity. But just remember that it is separate and apart from you, and it can do different things than you for that reason. Similarly, if you get a third-party discovery request, which is, it's common, and don't panic, but don't ignore it either. And there are mechanisms to deal with it too. You don't necessarily just have to turn over your documents. Certainly your proprietary confidential information, you don't have to turn over. A business attorney can help you figure out what your options are to deal with the subpoenas. You can ask the court to just strike the subpoena, or you can ask the court for a motion of a protective order as well, so that you can control what you have to disclose.
Hey, Greg, could you explain what a third-party discovery request is?
On the governance side, I would say that it's worth at least thinking through your bylaws or member agreement or the partnership agreement, just so you can understand how decisions are made in your business and what the roles even are and who does what. Maybe you do them all, but at least it's a good exercise to figure out what jobs fall under each role, so that when you scale, you can still be clear about what you're delegating to who. I think that's all for my slide there. So now, questions. Let's take a look. Meg, I was shared your email. So I was planning on mentioning that in the IP section, which is next. This next question, limited liability. Yeah, So I mentioned the sole proprietorship, you're personally liable for the debts. And like if you take out a loan and your business defaults on the loan, a sole proprietor will be liable for the debt. But if a corporation took out a loan and defaulted, then the debt stops with the entity and not with the owner personally behind the entity. So limited liability just means that you're not liable. You're not liable for that money if you're an owner of a corporation or LLC or LLP. You're not liable for that money that the sole proprietor would be liable for. I hope that makes sense. If not, sorry, everyone. I'm doing a bad job. I think my email was chiming and I muted it, but then I couldn't hear anything. So if I've been steamrolling, I apologize. David, I can hear you now.
Awesome. Yeah, no worries. I had just asked which question that other people have been asking as well. What is a third-party discovery request?
Yeah, third-party discovery request. So not to get too deep into the civil litigation piece, but there's let's say your business, let's say UMD sued Apple for trademark infringement. So there's the initial pleadings, and then the case moves into what's called the discovery phase, and that's where each side can make like broad requests of anyone, and their goal is to get the information they need to prove their claim in litigation. So even though you're not a party, the plaintiff or the defendant, either the plaintiff or the defendant can send you a subpoena and ask you to give information that you might have. Now, they could ask you like, okay, well, tell us about this IP, or tell us about your sales from these 5 years. And your question that you're going to be confronted with is, am I going to turn over this information, or do I have a legally valid reason for not turning it over? Or do I just not want to participate for another reason? So the subpoena is really the third-party discovery request. There's subpoenas for documents. There's also subpoenas to have people come and testify. And in the business context, if you receive a third-party discovery request, this is why you have to have a resident agent. I think I kind of glossed over it, but when you start your business, you have to have a principal place of business in the state, and you also have to have a resident agent in the state. The resident agent's job is to receive official documents and what's called process, like process is like a complaint and answer for litigation, the official documents that kick it off, or subpoenas as well, third-party discovery requests. So that's the resident agent's job, to get those documents. Now, when you start your business, you can be your own resident agent, right? You can save costs, you can just write it down. The Secretary of State has made it super easy to start entities. There's form fillable PDFs on SSTAT's website. It's easy to do. You could just write it in, scan it, pay the fee, you're done. But you should consider whether, if you're the resident agent, you should consider whether A, do you want your home address ostensibly in the record that SStat has. It's publicly searchable for anyone. Anyone can just find your business name and view a PDF of your articles of incorporation. And then also, if you do end up getting processed for whatever reason, maybe you get it through the mail, but maybe not. Maybe the person hires a process server to come to your house. So you just got to think about whether you want stuff like that happening. Maybe you don't mind, but maybe you would. But it's just a consideration.
Awesome. And Greg, there was one more question there from Herbode. He was going back into that limited liability question. So are there different levels of liability we can choose for an LLC?
Yes. So this really goes into the operating agreement. So the operating agreement really can do more to allocate risk among the members. It could set out like what each member's ownership interest is, and like I mentioned, the roles of each member, or which position which job in the LLC they're going to do. The operating agreement is super customizable too. So if it's really important and you really want to stretch the limits of what's possible, I think it's worth having someone with a lot of experience to draft you a custom one. I think there's like form ones that you can find. There's also a little nugget. If you look at the SEC's website, or they keep a database called edgar.gov. And on Edgar, you can find a lot of like business documents for larger entities who have SEC disclosure requirements. It's just a big repository of like corporate documents. You can find membership agreements there, partnership agreements there, bylaws, articles of incorporation, and there's a pretty huge breadth of sophistication among those documents. They're like some voluminous documents I've seen there. But if you just want to get an idea of what's possible, I would recommend just Google like edgar.gov, or maybe even ChatGPT can identify some operating agreement examples. But I would say maybe check that out and see if it has something that fits for what you're trying to do. Does let me know if that helped or if that answers. No questions?
I think
All right.
covered it. Yeah.
Great. If no questions, then let's march on to the IP section. So IP, sorry. My goal here was also to let everyone put their acronym bingo cards away for once. Feel like DC, all the government entities and nonprofits, think tanks, you can get drowned in these acronyms. So the acronyms that are going to be relevant for the rest of our talk, one, IP, I'm sure I've said that a bunch now. IP stands for intellectual property. Intellectual property comprises patents, trademarks, copyrights, and trade secrets. More on that coming up. The USPTO is the US Patent and Trademark Office. They control the issuance of patents and trademarks. And the copyrights are not under the USPTO, actually. They come from the Copyright Office, which is located in the Library of Congress on Capitol Hill. So they're not close. The USPTO is in Virginia, or the main office is in Virginia. Back to the slide. So this is a callback to the Maryland statute on corporations. Corporations have the power to acquire interest in property and also to convey those interests in their property and other assets as well. All right, slide 15. The assets that businesses can acquire. So business can have, obviously, everyone knows businesses can have like cars, computers, personal property. They can have real property like buildings and lands. They could also own personal property intellectual property assets like patents, trademarks, and copyrights. And they can monetize their interest in these assets with assignments and licenses. Licenses convey a limited time right to use intellectual property or use an asset, and assignments transfer the ownership wholesale to another entity. And usually the transfer is for money, but under contract law, it has to be for some value, usually it's for money. And another asset that is not procured in the way that patents, trademarks, and copyrights are is the trade secret. So I have a slide on trade secrets. Just keep in mind that they're there, but you don't procure them per se. Slide 16. So first, let's talk about trademarks. Because every business that has a brand and is trying to sell a good or a service has a trademark. I think people in the law would call like trademarks and copyrights soft IP, and patents, since they're more technical generally, is hard IP. But that's, I don't know, that's not an important distinction for the layperson. So a trademark, the overriding requirement for a trademark is that it has to be inherently distinctive. And the trademark distinguishes a source of goods and or services in the marketplace. So it really sets your brand apart and helps your business build loyalty around its goods and services. Trademarks are issued by the Trademark Office and Trademark Office within the USPTO. And trademark registration term can be indefinite provided you meet the renewal requirements. So between years 5 and 6, you have a filing due, and year 10, and every 10 years after, you have a filing due. But provided you make those filings, then you can have a trademark indefinitely. Next slide.
Oh, selfish question here, Greg.
Yep.
Is Mickey Mouse from Disney a trademark, and isn't it supposed to expire next year for Disney? I don't know if you know anything about that.
I think that's a good question. My knee jerk is to say that Disney has a copyright over Mickey Mouse, and just that like the derivative works of Mickey Mouse, like Donald Duck, Minnie, Pluto, Goofy. I don't know whether they have a registration. Oh, but I'm assuming this has been in the news.
Yeah, they're supposed to not have exclusive rights over the Mickey Mouse character anymore, because it's been 100 years. It's supposed to run out next year, supposedly.
So yeah, I think copyright is applicable, and the term of copyright, so this is on a slide later, but the term of a copyright is the life of the author plus 70 years. So every time I hear a Bob Marley song. Ooh, I feel like the Marley lineage is just caking off of Bob Marley songs. But anyways, the protection scope of a copyright or a term is the life of the author plus 70 years after they decease. And then after that, it is dedicated to the public domain.
Got it. Yeah, that'll be interesting to see. Thank you.
And I think Felicia answered. Okay, so I think I was mostly right, if not 100% right. So here, this slide reviews the, or to give you an idea of how long it takes to get a copyright once you file an application. So the steps for trademark procurement, sorry, we've been talking about copyrights, I think I misspoke. The steps for trademark procurement, yes, I will explain public domain in a minute here. The steps for trademark procurement, here they are. So at least my process, stage 0 is pre-filing. So I do a search of, the PTO keeps a register of registered trademarks and unregistered trademarks, but it is the trademark electronic search system. It's short TESS, another acronym, but if you search TESS USPTO, it'll come up. But you can do a search there if you want to do a high level search for a brand name that you're thinking about using. You can search in TESS and see what comes up. The test for whether the trademark law office will actually grant your registration, there's a few problems you could run into. One is your mark is confusingly similar to another mark that operates in your same commercial space. I think that's the most common rejection. Another possible rejection is whether your mark is merely descriptive of the goods and services as opposed to inherently distinctive. So, not to get too legalese, but a descriptive mark, if you're selling a battery, a descriptive mark could be like battery cube. But if you can argue the mark is suggestive instead of distinctive, or both suggestive and distinctive, then you can still get the registration even though it's merely descriptive. So, I think an example of suggestive would be like powered cube as opposed to battery cube. So it suggests a function, but it doesn't just tell you just like straight out in the name what it is. Sorry, I'm like jumbled between my notes because of these technical difficulties. But those are the primary rejections. The other one will come to me here. But total, I just wanted to make a note from that chart there, the 14.3 months. So that is the PTO publishes data about how long their applications run. And right now, I pulled this like earlier this week. Right now, the total pendency is 14.3 months. Now, this should come down because at the beginning of this year, the trademark office shortened the reply period for first office action responses. So sorry, not to jump around too much, but the timeline, you do the search, then you come up with your pre-registration filing strategy. you file an application with the trademark office. Usually file this online. There's a system called Trademark Electronic Application System. You file that application. It is maybe 8 months down the line, it's examined by the trademark law office. They send you a response called, well, they can send you a response called an office action that says, well, we're not going to give you the trademark registration yet because there's these problems and we're going to give you a chance to respond. But they don't have to issue an office action. They may just say, hey, your application is good. Your application is good, we approve it, but there's a good chance that's not going to happen. So if you get an office action, then you move into this prosecution phase, or it will be called generally prosecution. And that's where you negotiate with the trademark law office. Hey, I think I'm entitled to this registration, or hey, I will amend my application so that I meet the legal requirements, or I think you just got it wrong on the law, here's why. Then hopefully you get correspondence back that says, we agree with you, we're gonna allow your application to turn into a registration. At that point, your application, or excuse me, your mark is published in a publication of the trademark office called the Trademark Official Gazette. It sits there for 30 days, and the public has an opportunity, like anyone who thinks they will be impacted by the registration can oppose your registration. I think opposition is uncommon, but if your mark was inspired by a famous mark, let's say Nike, if it's inspired by any famous mark, I would caution you to just do a serious examination and contemplate whether opposition may happen to you, because that's a bummer. You get all the way down the line and then a big guy opposes your registration, and as a startup you probably don't have the wherewithal to fight with them. So, but I think that's rare. It doesn't happen, and then you get your registration. Your application, or excuse me, your mark will be registered on the Federal Principal Trademark Register, and you just have to do the renewals at year 5 and 6, and then every 10th anniversary. There are a couple bases for trademark registration. I won't go into them here unless someone wants me to, but I will say that if you are not yet using your mark, but you're getting ready to use it in 6 months, maybe you're still doing prototyping, or just doing some odds and ends, finalizing your design for your logo, you can still go ahead. If you're finalizing the design, you should wait, because you can't amend your application once you file it, really. But you don't have to wait until you're actually selling goods in the market to file. You can file a trademark application based on your intent to use your trademark. And when you get the registration, your date of use will go back to your filing date. So generally with IP, I would say first in time is first in right. So you want to go ahead and safeguard your IP, or take steps as early as you can. All right, slide 18. I think I went over all of this on slide 16. So the considerations, just to recap really quick, I think a clearance search is important. It is not prohibitively expensive to file a trademark application. It's about $250 per class of goods and services. But I think it's emotionally costly to wait that long and wait 14 months only to find out you're not going to get the registration, or you can't get a principal register registration. There's also a secondary register called the supplemental register. So you still have important rights on that register. It's better than no rights, but you get much stronger protections on a federal principal register. I went over the common rejections. Beware of the opposition. If your brand was inspired by another brand and that brand is, we'll say, famous, beware of an opposition. Opposition litigation can cost on the order of like $50,000 to $100,000. I talked about the discovery phase in the first section, but discovery is really what drives up the cost of litigation. So just beware of the possibility for opposition. And you cannot make material changes once your application is filed. The office would define material changes as if they have to search the register again, then they would call that a material change. So just know that you can't really change your design once you file your application. And then just another filing requirement, foreign filers have to use a US attorney. You can self-file a trademark application, but I think there's advantages to using an attorney. For when they understand the law. If you get a office action rejection, they don't have to get up to speed on what's going on. They can just kind of dive right in and work on your response. And that is also more important since the office action reply period just went from 6 months to 3. So you have less time. An attorney gets the official correspondence from the office. So there's a lot of scams, but they can just help you filter through the noise and separate the wheat from the chaff. And I think just having peace of mind about your registration being in good hands, or at least competent hands. So I don't think I have a question slide there, but maybe we can pause for some questions there.
Yeah, so can you explain public domain when you have a chance?
Yes. There's yes. So basically, the Congress's authority for regulating patents and copyrights is in Article 1. And Article 1 of the Constitution, it basically says to promote the progress of the useful arts and sciences. Congress can give monopolies to inventors and artists for a short time to increase the public knowledge and just like the state of the art, state of innovation generally. So public domain is just like all the ideas and tech and just any knowledge that is just like dedicated to the public and not subject to some inventor or creator's personal monopoly. So yeah, that's kind of what I meant by public domain. I hope that's a helpful explanation.
Yeah, thank you. And is there a difference between a federal trademark and a state trademark? And is there a preference for which one to get?
Yeah, sorry, I didn't mention that. So federal trademark, a federal registration on the principal trademark register, when your mark gets registered on the federal principal register, you get priorities in not just Maryland, but every US jurisdiction. So that means if someone else tries to use like a similar mark, you can say, no, I have priority to this brand and yours is similar. You were on notice because I registered it. You get priority in every state, whereas you can file for a trademark registration with the Maryland Secretary of State, but you only get priority in Maryland. So if someone in California is using your same brand, you would only have like regional protection against them, but you wouldn't have a right that you could assert to stop them from using your brand in their locale.
All right, and I know it's 11, so if people need to go, I understand. I know Greg offered to stay on a little bit longer, so I'll keep going here. Is it expensive to oppose or fight an opposition to a trademark?
Yeah, it is. It is. It's on the order of like probably 100,000 is a good guess. And yeah, I think it's not really feasible if you're, I don't know, if you're under a certain point, or if your company is like a certain maturity level or below. Spending 100K on litigation to use a brand doesn't make good business sense. It makes better sense just to pick another brand. It is, especially if you don't have like inventory with the branding on it. If you do have inventory with the branding on it, then it's more costly to have to destroy it and discontinue the use. But I think it just depends whether you can stomach that cost.
All right, and then Meg asked kind of about the public domain question. Public domain is companies say the Masai brand. If, for example, the Masai brand used by hundreds of companies is in the public domain, and we are saying it belongs to Masai, and they should receive a license from companies who use it, such as Louis Vuitton and others. We have filed their trademarks for several areas. Yeah, sorry if it's too much to address, but do you have any thoughts on that, I guess?
Meg, I'm happy to, I've offered office hours. I don't think I did a good job of publicizing it, but I've offered office hours for a while now. So I'd be happy to book an offline meeting to talk about this specific question. But I'd be interested to know whether you have a like an international registration through the Madrid protocol or not. Once you have a state or federal trademark, would you be alerted if someone is using your brand? Or would you have to find out? Yeah, you would actually have to find out. So the PTO has a beta tool. So I told you pending registrations are published in the Trademark Official Gazette. So they have a beta search tool. I don't think it's very good, but I guess your options are to set up a search with that tool, or B, you could have someone look at the register, like manually search the Trademark Official Gazette, or maybe you just hear about the mark, or it just comes up when you do a Google search. But it is an active process. So another thing that your business attorney could do for you is send cease and desist letters to putative or suspected infringers to assert your rights and put them on notice that you don't want anyone else using your brand without your permission. Is it really? Oh wow, it is 11. Do I have options if I can't afford to fight in opposition or can't afford to oppose another brand? It is, I think your best bet is, so there are options. You know, the main option is there's an agreement called a concurrent use agreement that's used in these trademark cases. So you can negotiate with the owner of the problem registration. You can negotiate an agreement that says like they're okay with you using the mark, or they don't oppose your registration. That's probably the lowest cost mechanism to get a registration if there is some sort of like objection from a third party. I think it's like situation specific, but yes, I think there's options. There's theoretically options to negotiate concurrent use. But I can't say with much certainty whether you'll be successful or not. But there's definitely precedent for that. And so I think we knocked out all these questions. So it's 11. I had slides on patents and I had slides on copyrights as well. One slide on trade secrets. So David, I don't know, I'd be happy to do a follow-on at some point, like a part 1 and part 2, but I don't know how much longer you want to keep going with this presentation.
Yeah, I guess part 2 sounds good to me. I don't know if anyone else has any last second questions here, and then we'll try to get Greg back to do another session.
So I can quickly, I could just give an overview of patents, trademarks, patents and copyrights and trade secrets, like a 5-minute overview.
Okay, let's do that, and then we'll sign off.
Okay, cool. So patents, patents protect like new and useful inventions. Patents also can apply to, or you can apply for a patent on a design. A design patent protects just the ornamental features of your invention, whereas the utility patent protects the useful functions of the invention. I'm going to save the subject matter, I'm going to save the legal requirements for another talk. But if you've ever had a debate with people about which way to hang the toilet paper, there's a patent that explains it for everyone. Even though another patent attorney I know said if you have kids, you won't hang it that way because they can unroll the whole thing before you even know what happened. Grain of salt. Slide. I think slide 25 explains copyrights. Copyrights are protect original works of authorship fixed in a tangible medium. So like art, movies, even architectural drawings are copyright eligible, actually. We talked about the copyrights in Disney's IP. The term is the life of the author plus 70 years. The scope of a copyright is the work itself and also derivatives. So The example I have here is Fast and Furious, and then Hobbs and Shaw, the offshoot, is the derivative work. So that would be protected under the scope of the copyright as well. And just one nugget, if you hire a vendor and they make copyrightable work for you, then you and not the vendor own the copyright in their creation. So it's called a work for hire. Just keep that in mind. Like if you go on Fiverr and have a designer create a logo for you, they don't own a copyright in the design. You own it. And trade secret. A trade secret is a commercially valuable secret, and the value in that secret is keeping it out of the public's knowledge domain. The way you protect a trade secret is you don't file an application for it, but if you have to go into court for trade secret misappropriation, you need to be able to prove that you took reasonable steps to protect your secret. So reasonable steps can be as simple as like a non-disclosure agreement, or some reasonable steps are a non-disclosure agreement or a non-compete agreement. So, if an employee separates from your business and they take your customer list and they start soliciting your customers, well, your customer list was not known to everyone, and you derived value because you knew it and your competitors didn't. So that's a trade secret. You could sue that employee, or your business could sue the employee for trade secret misappropriation. So, yep, that's a nugget about that. And, just lastly, I will say that I know we didn't get to go over everything here, but I do. My Calendly page is the last slide. The link to my Calendly page is on the last slide, but I do support like patent, trademark, copyright procurement, and you could book a strategy session there at my Calendly, and yeah, we could go into the specifics of your use case, or if you have another business problem, happy to talk about that as well. Hopefully you don't have to litigate anything, but there's non-litigation tools that we could also leverage. And like I was telling Meg, I have office hours, or I have office hours appointments as well. So I try to limit those to non-confidential details, but these are the places you can find me online. And I think I listed my email there too, so feel free to email me as well. And I can send these slides out, and I'll work with David and Ala to set up a part 2 for this.
All right, thank you so much, Greg. Super informative. And thank you everyone for coming out. I'm sure we're going to get Greg back because a lot of rich content that he was getting into that we didn't get time to address. All right, so I'm going to stop share.
Thanks, everyone. Thanks for sticking around.